The October 2025 federal indictment of former National Security Advisor John Bolton marks a critical juncture in the ongoing legal and political battles over the handling of classified information by high-level U.S. officials. Bolton, who served under President Donald Trump before becoming a vocal critic, faces an 18-count indictment, 8 counts of unlawful transmission of national defense information, and 10 counts of unlawful retention of national defense information. These charges, filed under the Espionage Act, stem from allegations that Bolton illegally used personal, unsecured email and messaging accounts to share over 1,000 pages of his diary-like notes with 2 unauthorized family members, sometimes containing information classified as high as top secret. The core of the legal charge lies in the alleged willful nature of the transmission and retention. The indictment specifically details how Bolton used non-government platforms to communicate highly sensitive intelligence, including U.S. plans for covert action, and details about foreign adversaries' capabilities and intelligence sources. A major national security angle is the claim that classified information was compromised in 2021 when a cyber actor allegedly linked to the Iranian government hacked Bolton's personal email. This case draws comparisons to previous classified documents investigations, but distinguishes itself by focusing heavily on unauthorized transmission to private individuals, rather than just retention, suggesting a systematic disregard for established security protocol. Reasons for mishandling and prosecution. The reasons for the alleged mishandling are twofold, encompassing issues of personal practice and professional recklessness. First, at a personal level, high-ranking officials like Bolton often maintain detailed contemporaneous notes for memoirs or future historical reference. This practice, while common, becomes dangerous when, as alleged, officials choose convenience over security, utilizing personal accounts and sharing sensitive material with non-cleared individuals. The indictment suggests Bolton's intent was tied to his writing, referring to the recipients as his editors, prioritizing personal legacy over security procedures designed to protect sources and methods. Second, the reasons for the prosecution in late 2025 are intensely political. Bolton's indictment follows similar charges brought by the Justice Department against 2 other prominent critics of the current administration: former FBI Director James Comey and former New York Attorney General Letitia James. This pattern has led Bolton and his legal team to assert that the charges are not about national security, but are part of a targeted campaign of political retribution against the president's opponents. This allegation of a weaponized Justice Department, even if unfounded, provides the primary motivation for the timing and visible intensity of the prosecution, setting a high political barrier for the Justice Department to clear. Consequences: legal and political fallout. The consequences of this case are vast, spanning the legal system and the political landscape. Legally, a conviction on any of the 18 counts could result in a lengthy prison sentence, as each count carries a maximum of 10 years. More significantly, the case will involve the use of the Classified Information Procedures Act, which governs how classified evidence is introduced in court. The sheer volume of classified material involved, including intelligence on foreign adversaries, will force difficult decisions about what information the government can allow in open court without further jeopardizing national security, making the trial itself a security risk. Politically, the consequences are immediate and severe. The prosecution of a longtime Republican foreign policy figure and a high-profile Trump critic further intensifies the public debate over selective justice and institutional independence. It feeds the narrative that the Justice Department is enforcing a 2-tiered system based on political alignment. This deeply undermines public trust in the neutrality of law enforcement and intelligence agencies, further fracturing the political environment and making future administrations even more wary of cooperating with post-tenure investigations. Furthermore, the alleged exposure of national defense information to Iranian-linked hackers constitutes a direct national security consequence, demonstrating that lax personal security practices by former officials have tangible, dangerous geopolitical risks. Prediction and future outlook. The prediction for the trial is that it will be highly contentious and lengthy. Bolton's defense team is expected to challenge the core evidence by arguing that the documents were decades old, already approved for publication in his memoir, or were subject to overclassification. Crucially, they are expected to mount a strong defense based on the political context, alleging that the prosecution constitutes selective or vindictive enforcement of the law, an argument that, if successful, could lead to a dismissal of the case entirely. Given the precedent set by previous political investigations, the case is unlikely to conclude quickly. The trial may become a public spectacle, forcing the disclosure of sensitive government practices under Classified Information Procedures Act proceedings, potentially creating more security headaches for the government than it solves. Ultimately, the outcome may hinge less on the narrow facts of classified markings and more on whether the court finds sufficient evidence of criminal intent versus political motivation. Solutions to prevent future mishandling. The systemic failures highlighted by this and other classified documents cases demand comprehensive, nonpartisan solutions to secure national defense information. Mandatory digital offboarding. Establish a strict, mandatory digital turnover protocol for all departing senior officials. This system should automatically review and secure all personal electronic devices and non-government email accounts for classified data immediately upon the official's departure, similar to physical document retrieval. Independent pre-publication review. Create a fully independent, non-political board staffed by career intelligence professionals rather than political appointees to handle the pre-publication review of memoirs. This board must operate under a strict, fixed timeline to prevent delay tactics and political manipulation of the classification process. Enhance training and penalties. Implement mandatory annual refresher training on the Espionage Act and digital security for all individuals with top-secret clearance. Furthermore, administrative penalties, such as permanent revocation of all security clearances and government pension forfeiture, should be swiftly and consistently applied for confirmed instances of willful negligence, creating a powerful disincentive. By addressing the systemic issues related to both security procedure and the political weaponization of the classification system, future administrations can better safeguard sensitive information and restore public confidence in the legal handling of government secrets.